Hi, everyone. My name is Jacob Schneider. I'm a staff attorney at the Center for HIV Law and Policy, and I'm here with a couple of my colleagues to talk a little bit about HIV criminalization, some of the basics of it, and where we're heading. This was initially planned as an in-person session for AIDSWATCH this year, but under the circumstances with the coronavirus, it was changed into a webinar. As a result, this is being pre-recorded, and so you won't be able to ask us questions contemporaneously, but we do want to provide you with our contact information. These are our email addresses, and we're really excited to talk about the topics that we're going to cover today, and we would love to hear from anyone about any reactions and thoughts and ideas that spring from it. So just an overview of what we're going to be covering today. We're going to start off with just kind of a quick overview of the basics of HIV criminalization, defining some of the terms that we're going to be talking about, and discussing some of the policy landscape. Then we're going to do kind of an overview of some of the criminal law reforms that have successfully been achieved and what some of the pros and cons of those. And then we're going to talk a little bit about molecular HIV surveillance and public health surveillance generally, and how this is something that we're tracking very closely right now and thinking about the ways in which it intersects with HIV criminalization. So I'm going to kick things right now to my colleague, Jada Hicks, who's going to start with kind of an 101 of HIV criminalization.
So I'm going to start by just defining what HIV criminalization is, since sometimes there's some confusion surrounding that. HIV criminalization is the arrest, prosecution, and imprisonment of people living with HIV for things that are perfectly legal or only minor crimes for people who have not tested positive. So in other words, your HIV status combined with some sort of conduct is used as a basis to single out people living with HIV for unique and discriminatory treatment by our criminal legal system. So the scope of HIV criminalization laws, this is just going to be a quick rundown of HIV criminalization and the scope of that within the United States and how different states treat HIV criminalization. So currently there are 34 states and several US territories that have HIV-specific criminal laws or some sort of criminal law that singles out people living with HIV. If there is not an HIV-specific law, many states, a person living with HIV can be prosecuted under general criminal laws. So when we say general criminal laws, that will be something like assault or reckless endangerment, where your HIV status is classified as some sort of dangerous weapon. We see that in Texas, New York, Massachusetts, just to name a few states. Many states also use both HIV-specific laws and general criminal laws. So whatever your conduct falls under, they can pick and choose. There are states that also criminalize through the public health code. Currently, there are 6 states that require registration as a sex offender. This does not have to be a result of actually engaging in sexual conduct. In a number of these states, it's enough to just be living with HIV and either agree to engage in some sort of sexual conduct or engage in a low risk or no risk sexual activity in terms of transmission, such as oral sex. So what behavior are we talking about that's criminalized when we're speaking about HIV criminalization? So most often we're talking about sexual conduct without prior disclosure of your status. And correctional facilities and mental health facilities and interactions with police, we oftentimes are talking about spitting, biting, or other modes of exposure to bodily fluids. It's typically going to be in those settings. There are also sentence enhancements for people who engage in sex work, or if someone living with HIV then decides to share injection equipment like a needle with someone without disclosing their status as well. And also there are sentence enhancements for people living with HIV if they commit an underlying sex crime. So it will be used to increase your sentence during the sentencing phase of a trial. We also have blood and plasma donation, which, as we all know, there's a rigorous screening process, but there's still laws on the books where if a person living with HIV attempts to donate blood, plasma, tissue, or organs, they can still face felony charges regardless of the screening process, which means that it would be screened out and no one would actually be contracting HIV through that donation process. So here, this map is also on our website, Center for HIV Law and Policy, so hivlawandpolicy.org if anyone wants to check it out. It gives you an overview of everything we've just covered in terms of scope of criminalization, and it is also color-coded. So we've got the 34 states that have the HIV-specific laws. You've got the yellow balloons for the sex offender registration requirements in those 6 states. We also have the green balloons, which show which states have reformed or repealed. So Amir will get into that a little bit later in the webinar, but this just highlights overall which states have done what. And then down at the bottom, we have a breakdown of states with HIV-specific criminal laws, states with sentence enhancements, and states where people living with HIV can be prosecuted under general criminal laws. And so all of that is broken down and kind of highlights the scope of HIV criminalization that we've been discussing thus far. So models for criminalization. When we're talking about HIV criminalization, how exactly does this look in the law? What are prosecutors using to charge people? And so this is just a breakdown of the models for HIV criminalization. So typically, you're going to have an HIV-specific criminal law. And please keep in mind when you're looking at the language of these statutes, this is not my language, but it's a specific language from the statute. I wanted to keep that in there so that you could all see the language that they use. It does highlight some of the stigma that surrounds these laws and people living with HIV in general. So what I've got here is an example from Georgia, where if you knowingly engage in sexual intercourse with the sex organs of another person, and you have HIV and don't disclose that, it could be a felony and you could face up to 10 years imprisonment. So that is an example of a specific HIV criminal law. On the right side, we also have an example of a general criminal law. So in New York, you can be charged with reckless endangerment if you engage in create a substantial risk or serious physical injury to another person. Again, that there is your HIV status being weaponized and seen as a weapon that creates some sort of substantial risk just by engaging in sex. So that would be something that would be a misdemeanor and you could face up to 1 year in prison. So this is typically what we're seeing when we're talking about models of criminalization and how people living with HIV are criminalized under state laws. We also have the health code, so I touched on that briefly. So an example of this would be Ohio. They have not only an HIV-specific law, but they also have a portion of their health code where a person living with HIV could face some sort of prosecution. And that specific code talks about exposing others to contagion. And so that would be a misdemeanor for up to 90 days, but they also have this HIV-specific criminal law where you could face up to 8 years in jail. So the public health code is kind of another avenue that we see being used to target people living with HIV. So in terms of HIV criminal prosecutions, we're just going to break down typically, and this is not for all states, but for most states, how the law works and how it's written. And in most states, transmission is not required. It's not even a factor that they consider. So it doesn't matter whether or not a person actually transmitted HIV or even if they meant to transmit. That's not something that they factor in. Risk of transmission is largely irrelevant. Again, we have a lot of activity that is being criminalized that is either low risk or no risk whatsoever. And that's by scientific medical standards and according to the CDC as well. So we also see that risk reduction measures are not typically a defense. So that means if you're using condoms, if you're virally suppressed, or if you're using any other type of prophylactic device, it's not usually considered or spelled out as a defense. Again, we're talking about negligible or zero risk activities such as oral sex or spitting that are still being criminalized and we're still seeing as high-level felonies. Intent to harm is not required. So again, you don't have to intend to transmit or intend to cause any sort of harm to the other individual. And oftentimes proof of disclosure is often the only defense. So that is exceedingly difficult to prove in court, and it is usually one person's word against the other in terms of did that person disclose their HIV status prior to engaging in some sort of specified conduct, usually some sort of sexual activity. We're also seeing severe and disproportionate punishment. So we're seeing people living with HIV who are facing sentences that are more sometimes than people get for murder or second-degree murder charges in certain states. That's how severe the punishment levels can be for people living with HIV. So what's the problem with HIV criminal laws? First is that it's not an easy disease to transmit. And we have not only the scientific, but the medical knowledge to back that up, that it is not easy to transmit. It is now currently a manageable chronic condition. When HIV first came about, it was seen more as a death sentence, and that's just not the case anymore. And in fact, with treatment, a person in their 20s can expect to live a near normal lifespan. So it's really dated and on these outmoded ideas that HIV is a deadly weapon. And so we're trying to catch up the criminal laws with our current science and data that we have surrounding HIV and surrounding routes and risk of transmission as well. So HIV criminalization does nothing to promote public health goals and doesn't get us any closer to ending the HIV epidemic. There's no evidence that these laws deter risky behaviors or that they even promote disclosure of one's status. There's no evidence that HIV diagnoses have decreased in states that criminalize HIV. In fact, there's actually a disincentive to learn your HIV status because the one requirement for every state is that you must know your status in order to face prosecution. It alienates patients from healthcare workers, sends a one-sided message regarding sexual health and prevention responsibility. So we really should be pushing that sexual health and responsibility is on both individuals, and they are both in charge of their sexual health. We should not just be putting the onus on the person living with HIV. It already harms marginalized populations, including people of color, LGBTQ communities, sex workers, and undocumented immigrants. And it also continues to promote stigma and fear that surrounds HIV. So as part of combating HIV criminalization throughout the country, in 2010, the Center for HIV Law and Policy developed the Positive Justice Project. And we actually have a set of guiding principles that we use within our efforts to reform HIV criminal laws. And this will tie in a little bit with what Amir is talking about in terms of reform efforts and what we like to see incorporated in order to reform these laws. So no disease-specific criminal law or sentence enhancement. We aim for requiring specific intent so that you intend to transmit HIV, and it has to be coupled with conduct that's likely to cause the intended harm. So we're trying to get rid of any sort of law that criminalizes low risk or no risk activities. Risk reduction measures should mean that there is no intent to harm. So if a person is using condoms, prophylactic devices, or medication, regardless of viral suppression, then that means that they don't have an intent to harm. We're also trying to get proportionate penalties. So no felony punishment and no sex offender registration requirement is what we aim for in our HIV criminal law reforms. And that kind of ties in with what some of the states have been doing. So I'll go ahead and pass it over to Amir.
Thank you, Jada. My name is Amir Sadeghi. I'm the National Community Outreach Coordinator at the Center for HIV Law and Policy. And I think as we pivot this discussion into reform, I'd like to segue a little bit by having a clip play from Mandisa Moore O'Neill, who's a Black feminist attorney in Louisiana. And her and I actually recently collaborated on a webinar. So I'd like to play a clip from her about legal literacy's role in reform. Mandisa, you're an attorney in Louisiana, and you also mentioned that you're a member of the Louisiana Coalition on Criminalization and Health. What role do you think legal literacy plays in fighting for reform?
Well, to me, in my experience and my work, it plays a huge role in terms of, that's one of the things that that policy and lawmakers are really depending on us not knowing how these things actually work, and growing the idea that only people that have a JD or people that are practicing attorneys are the only people who can understand certain things about the law. And so to me, it's important like that we really unpack, demystify, complicate, and deconstruct that idea because it's not true. You know, like people who are experiencing the brunt of these policies know very well what's wrong with them and know very well what needs to be done, like in order to make it less harmful.
I'd really like what Mandisa just said to be a big theme for what I'm going to discuss right now, which is giving you a national landscape on reforms to HIV criminal laws. So here we have some of that data briefly summarized in a chart with some dates on the left side. And you can see that, that HIV criminal statutes were enacted at least as early as 1986, though many of them we see begin to develop around the time that the Ryan-White Care Act came about, which also conditioned a lot of state funding on whether a state had a statute that could be used to prosecute people for intentionally transmitting HIV. And we can see some of that data conveyed in a different way here. And then finally, here's a timeline that's also published on our website that I'm going to go ahead and provide a little bit deeper of a dive by giving you some perspective on the reforms to these HIV criminal laws that have taken place between Texas repealing in 1994 all the way up until very recently when Washington's legislature passed its bill, and it was just recently signed by the governor, actually. So what some of those charts and this data do is they bust some myths. And contrary to some popular talking points, it's not true that HIV criminal laws were adopted way back when people knew little about HIV. We could see that states were continuing to adopt HIV criminal statutes well beyond the 80s and early 90s. And that actually some of the substantive changes to those laws made them more severe and not less. They maybe expanded the scope of prosecution or added new offenses or tiered levels of offenses. And that HIV is not the only disease that is criminalized, but most STI and communicable diseases, disease laws impose misdemeanor punishments, though sometimes it depends. They're not as widely enforced usually as HIV criminal statutes. So I'd like to define some of the terms that I'm going to use today, like repeal, which means a legislator completely removes an HIV-specific law from the state's codes, but that leaves prosecutors with broad discretion to use the general criminal code. Modernization is a term chosen in the early discussions with officials to describe reform or repeal of HIV criminal laws. And the idea was by appropriating the term that CDCs and state health officials used, we could put HIV criminal laws on a modernization to-do list. And then there's the strategy that the legal expertise at the Center for HIV Law and Policy supports, which is reform or effective repeal. So we cabin the prosecution of person-to-person disease transmission in a single law, and we limit, in this kind of reform strategy, a prosecutor's option to use the general criminal code against people living with HIV. What are some other options that I think a lot of advocates in the criminal legal reform landscape use, like restorative justice? Well, it might not work for HIV criminal law reform because it starts with the assumption that harm has been done to another person and engages the person who suffered harm more actively in determining how that harm would be addressed. So in the scope of HIV criminal laws, it doesn't really challenge the premise that people living with HIV harmed a person with the non-disclosure of their status. So in 1994, Texas made history and repealed its HIV criminal law. But like I suggested just a moment ago, it left broad discretion for prosecutors. And people living with HIV have been prosecuted for aggravated assault, which is assault with a deadly weapon or assault that causes serious bodily injury, aggravated sexual assault, attempted murder, and harassment of a public servant. So what we see there is there hasn't been a meaningful improvement in the lives of people living with HIV if they can still be subject to prosecution with the general criminal code, and really this kind of wider discretion for a prosecutor to pursue charges and the lengthy felony punishment levels that are associated with those. Illinois revised its HIV criminal laws in 2012. Prosecutors must now prove specific intent to commit the offense. And the reform also redefined sexual activity to include only anal and vaginal intercourse. It limited prohibited contact to anal and vaginal intercourse without a condom, but a prosecutor can subpoena medical records to show knowledge of a person's HIV status. Disclosure is not a defense to prosecution, and it's not clear whether the use of antiretroviral treatment could be the basis to rebut intent to transmit in the code. Prosecutors in the courts continue to infer intent to harm from the intent to have sex while living with HIV, and that's a huge issue and something that I think advocates who are organizing to reform HIV criminal laws need to be aware of. And there's a felony penalty for that's punishable by up to 3 to 7 years, and transmission is not required for that offense in Illinois. So that's an issue too. Iowa reformed its HIV criminal law in 2014. It eliminated sex offender registration, including retroactively. It significantly narrowed the definition of intent and reduced penalties for some types of exposures, but kept a possible 25-year sentence. And in addition to HIV, it added other diseases now eligible for felony prosecution. So people living with hepatitis, tuberculosis, and meningococcal disease are now subject to felony prosecution, where before this reform, those diseases weren't added to that statute. The reform in Iowa, in a way, expanded the scope of prosecution by adding new diseases eligible for criminal punishment. So using practical means to prevent transmission is a defense to prosecution in Iowa, however, and prosecution can only occur for behaviors that pose a substantial risk of transmission, which is an improvement for HIV because, as Jada noted not too long ago, it's a disease that's quite hard to transmit, but there are other diseases now eligible for criminal prosecution in Iowa that can be transmitted casually, like tuberculosis. Colorado reformed its law in 2016. It reduced penalties for people convicted of sex offenses who test positive for HIV, and it eliminated mandatory HIV testing and the felony sentence enhancements for sex workers living with HIV, which it's a huge improvement because most of the convictions and the data that in Colorado showed that many of the arrests and prosecutions were related to sex work and HIV non-disclosure. Treatment for people living with HIV convicted of sex offenses improved, but they're still severe. If a sex offense involved anal or vaginal intercourse or oral sex and transmission of HIV is alleged, the penalty can be increased triple the minimum sentence one would receive if they were not living with HIV. So prior to this change in the law, transmission of HIV was not required. The sentence penalty could be at least 3 times the upper limit authorized for the offense. California reformed and repealed sections of its law in 2017. The law is no longer HIV specific. It reduced penalties across the board, including for HIV-related sex work convictions. So it requires intent to transmit, transmission, and conduct posing a substantial risk of transmission for prosecution. Blood, tissue, semen, and breast milk donation and solicitation by a person living with HIV are no longer felonies. Intentional transmission is a misdemeanor in California. So a lot of these bullets here really highlight California as a gold standard reform that we believe, and the attorneys at the Center for HIV Law and Policy believe, should be used as a watermark for reform as we continue on this long process. North Carolina reformed its HIV control measure in 2018. So North Carolina does not have a statute in the criminal code, but in the administrative code, there's a control measure. And people living with HIV must either disclose their status prior to sex or wear a condom now, unless they adhere to a treatment plan and have been virally suppressed for 6 months, or their partner is also living with HIV or taking PrEP. But a violation of this control measure is punishable by up to 2 years imprisonment, and neither in transmission nor intent to transmit is required. Michigan revised its HIV criminal law in 2019. It narrowed the scope of punishable sexual activities to include only vaginal and anal intercourse. It retained the felony punishment for non-disclosure of status and acting with a specific intent to transmit, however. Also, non-disclosure of status and transmission occurs, but not acting with an intent to transmit is a felony. Those who can prove extended viral suppression and consistent compliance with the doctor's care can use that as a defense to reckless exposure. But just like in North Carolina and Michigan, we want to make sure not to exacerbate or reproduce a viral divide between those who can be subject to prosecution and those who could avoid prosecution because they have access to antiretroviral treatment and have a successful linkage to care. Finally, Washington reformed its HIV criminal law this year in 2020. It reduced penalties for HIV exposure from a felony to a misdemeanor, requires specific intent to transmit HIV and for transmission to occur, and it removed the requirement for sex offender registration. The new reform in Washington affords people living with HIV with affirmative defenses to prosecution that were not previously available. If a person misrepresents their status to a sexual partner, intends to transmit, and transmission occurs, they would be subject to a higher penalty of a gross misdemeanor. But the kind of downside and the bad news in Washington that we know was a tough choice in the legislative compromise process in Washington with the advocates there is that it's still a felony penalty for people living with HIV who are convicted of transmitting HIV to a child or a vulnerable adult. But such a conviction would usually be prosecuted as a sexual offense anyway. And actually the code still requires sex offender registration if transmission occurs or is alleged where the victim is a child or a vulnerable adult. So what are some of the takeaways from this wide legal landscape? I think number one, we should be cautious of total repeal. With Texas as an example of how prosecutions continue, if we don't cabin prosecution of person-to-person disease transmission in a single law, and if we don't limit a prosecutor's option to use the general criminal code, coalitions should be broad and inclusive to reflect cross-movement organizing in the state to make sure that all of the affected communities are engaged in advocacy and reform. Advocates should first engage in a proactive education campaign on HIV and STI literacy, targeting policymakers, but also other criminal legal stakeholders like law enforcement, sheriff's offices, and so on. Reform shouldn't deepen or cave to the socioeconomic disparities in the enforcement of the criminal legal system. For example, advocacy and legislative strategies in some states have left behind key affected groups who would still be criminalized. We must not embrace a reform that reinforces the criminalization for communities already more likely to face enforcement in the criminal legal system, and that the political realities of a state are determined by the size and breadth of a coalition actively engaged in that campaign. So ultimately, we energize and mobilize communities towards action and change with a broad, inclusive movement and with an ambitious goal. And I think that truth doesn't change just because there's a seemingly unworkable political majority in your state. We can't justify leaving marginalized communities behind in reform, especially the groups who are most overrepresented in arrests and prosecutions. So we think that reform that, a reform targeting to change a law or policy should make sure that it's taking some scope from the community who are actively being criminalized. So with that, I will hand it to Jake.
Thanks, Amir. And I think that those were some instructive takeaways that really point to the fact that there's a lot of ongoing work to be done in terms of addressing criminal laws. And of course, we have a lot of information about that at our website, HIVlawandpolicy.org. I'm going to switch gears from talking just about criminal laws to talking about other laws and government programs that intersect with HIV criminalization, but that I think highlight the need to be vigilant, not just in terms of thinking about criminal law reform, but also thinking about ways in which other things can interact with criminal law to enhance risks of criminalization. So specifically, I'm going to be talking about public health surveillance and some developments we've seen there, and what we're doing about it at CHLP and ways that we think people can advocate around that. So a lot of people have probably, and I first just want to say that I'm going to do a pretty quick run through. Most of the information I'm going to be going through here is available on our website, HIVlawandpolicy.org. We have a longer webinar that explores some of this stuff in a lot more detail with a public health perspective of a public health official. We also have a fact sheet which distills a lot of this information, and that's available on our website. So a lot of people have probably heard about molecular HIV surveillance, but may not know exactly what it is. So I'm going to do a quick run through of some of the basics of the science and some of the reasons why we're concerned, especially the ways in which we think it can interact with HIV criminal laws in troubling ways. So HIV surveillance, public health surveillance, is something that has always been part of the tool bag that public health officials have in dealing with disease transmission. And that involves, using data to track who has tested positive and the ways diseases have spread. What's a little bit different about molecular surveillance, and why this is kind of a troubling new development, even understanding that public health surveillance has always been part of the public health tool bag, is that it's highly detailed personal information, and it's drawing on individual personal health information that's provided to a doctor for purposes of one's own treatment. So the way it works is that when a person who's diagnosed with HIV is working with a doctor to develop a treatment plan, one of the first steps is that the doctor will do a blood test to determine what drugs the person's particular strain of HIV will be receptive to and resistant to. And that's in order to, not for purposes of wider public health, that's for someone's personal health, for purposes of getting them the right medication that will effectively treat their disease. Now, in a lot of places, doctors are required to report that information to health departments, which are using it for other things, including, we're concerned, potentially criminal law enforcement, which is obviously not the reason that the patient provided that information to the doctor in the first place. So how does this work? So many of you probably know that HIV is a very quickly evolving disease. And as a result of that, no two people's strains of HIV are exactly the same at the molecular level. When you really dig into the genome and look at the makeup of the disease, and so we have this kind of crude diagram. A lot of you have seen things like this that that look at DNA and RNA replication, the way a virus creates new copies of itself. The HIV, there are a lot of mistakes in that process, and so it evolves pretty quickly. And so that means everyone kind of has a unique kind of fingerprint on their strain of HIV. And so public health officials can use that fact, the fact that HIV evolves pretty quickly, to compare two people's strains of HIV and use that to guess how close those people are in a transmission network by kind of measuring how close their genetic codes are. And so for these purposes, my understanding is that if you're within 0.5%, meaning if two strains of HIV are 99.5% similar, they're deemed closely related. And again, the way that public health officials even have access to this is by accessing personal treatment information that people have provided to their doctors for treatment resistance purposes. So there are a couple of different kinds of clusters that the CDC talks about when it talks about surveillance. And I think that this kind of illustrates how much more precise this molecular surveillance information can be. So a time-space cluster, that's kind of traditional surveillance, which is just kind of looking at patterns over time in terms of the number of diagnoses, and thinking about, are we seeing a trend just from that data alone? A molecular cluster is a lot more specific because you're not just looking at, kind of crude numbers of how many people have been diagnosed, but you're actually digging into their personal strains of HIV and looking at how closely related they are to try to identify people who are kind of connected in a quote unquote cluster. And so you may have seen kind of like visual representations of this, like these maps from AIDSView, which are able to show kind of some of this, information in terms of, identifying where HIV is rapidly spreading and amongst whom. So it's important to understand kind of what this data can show and what it can't show with the current level of science. So we know that it can show that that scientists can infer that if two people's strains of HIV are within 0.5% of each other, that they're closely related in a quote unquote cluster. What it can't show right now, and this is good news, is that one person infected another person. So this is a diagram from the CDC that kind of shows why. Because even if two people's strains of HIV are closely related, you don't know if maybe there was a third person who was kind of a link between them, or if there's a third person who transmitted HIV to both of them, and that's why the strains are closely related. So obviously that's good news on the criminalization front, because it means it's not smoking gun evidence that one person transmitted to someone else. But I think one thing we want to keep in mind, and I'm going to talk about this as we go on, is that we know that scientists are working on developing these scientific techniques further, and we can expect that one thing they might be able to do in the future is actually say definitively if one person transmitted HIV to another person. So why is this on our radar right now? So I think that for a lot of people, this kind of burst onto the scene a couple of years ago when the CDC announced a 5-year program to require states to ramp up their use of this technology. That program was called PS 18-1802. It was kind of a mandate to the states. It's not an opt-in thing. It's something that the states required to do in order to receive surveillance funding from the CDC. And this generated a lot of conversation amongst community members, amongst people who work with people living with HIV and people living with HIV themselves, because I think this announcement caught a lot of people by surprise. These aren't well understood scientific techniques, and there hadn't been a lot of discussion of the implications of this before the CDC went ahead and mandated it. And so perhaps in response to that conversation in the community about whether it was appropriate to move forward with this so quickly, the CDC did kind of take a step back and require that states take some steps, which I've outlined on this timeline right here, to get some community input and engage in community engagement. Of course, we're in 2020 now, and I think people have had very varied experiences as to how much their states have actually engaged them in that conversation. So why is this something we're concerned about? I'm going to walk through a few of our basic concerns. And again, a lot of this information is also available on our website. So if I walk through this a little bit quickly, just for purposes of time, feel free to reach out to us and look at our resources on the website. Jada and Amir gave a really good rundown of how HIV criminalization statutes work. And one of our concerns about molecular surveillance is just a really practical one, which is that it could feed into that already existing system of criminal laws. Because in some states, we know that there's a practice of using public health information in prosecutions, or at least statutes would permit it. One example on here is Missouri, which we know, as Jada and Amir discussed, is a state with an HIV criminalization law that also has a statute that basically requires public health officials to share the information that they have. So, when you get this really detailed personal health information that, that can really provide a lot of circumstantial evidence, if not, smoking gun evidence of transmission, how does that work in a state where you actually have a law that criminalizes that? And just to be really clear, like I said, right now the science doesn't allow you to say definitively that one person transmitted HIV to another person based on the molecular surveillance data. But we do think that that doesn't mean that there's not a risk of criminalization for a couple of reasons. One is that, circumstantial evidence is often used to convict people in criminal cases. And so the fact that the scientists accurately tell us that it doesn't definitively say that one person transmitted HIV to another person right now, doesn't mean that it won't be relevant in court and be persuasive to a judge or a jury. And that's especially the case because we know that judges and juries aren't always scientifically literate and may not really understand the limitations of the science right now. And we know that because we've seen it in cases like the Michael Johnson case, in which judges and juries are able to make a lot of inferences, whether correct or not, about the direction of transmission just based on circumstantial evidence. So we think this is a real concern in court, even if it's true that the science doesn't support using it as smoking gun evidence. And also we think this is a concern because, we know that science is going to advance. And when we're thinking about developing policies that protect people right now, we should also be anticipating kind of the next advances. So what happens when new molecular surveillance techniques are developed that do demonstrate the direction of transmission? Why wait until then to think about the implications of that? And just one other wild card that we want to throw out there, because none of us really know how this interacts with anything, is that, we're not only thinking about criminal prosecutions. And right now, I know a lot of people are thinking about immigration law and the new public charge rule, which, basically penalizes people who are seeking immigration relief, who might, be drawing on, public resources. And so how would, the fact of an HIV diagnosis be relevant there? We don't really know definitively, but we think that we need to be thinking about that when we're thinking about collecting data from people. Okay, so this is just a summary of kind of some of the criminalization risks we've already discussed. The other thing is that data security and privacy. We know that one thing people are concerned about when the government is collecting large amounts of data is, are they going to keep it safe? I would recommend that people who are interested in this topic take a look at this policy brief from NASTAD that runs through 10 states, which are kind of exemplary, a diverse group of states. And what they found was that there's real variance among the states of how well state law actually protects this information. And that's not to mention the fact that states sometimes screw up and their data breaches. That's not at all uncommon, unfortunately. And so that's going to be a risk. And the more personal and intimate the information that the government has, the greater the implications of that risk. one other thing that just we want to keep an eye on is that one thing that that we know public health officials say should make us feel a little bit safer about the amount of data they collect is that they remove identifying information from that data when they put it into kind of these big databases that they use to compare strains of HIV. But we also know that that so-called de-identification is not a perfect way of protecting people, that actually you can use what can seem like scant data to re-identify people based on zip codes, based on addresses, based on ages and gender markers. And so we need to think in a more sophisticated way about whether de-identification actually is protective enough. And another thing, and just really quickly, also, I just think we should be thinking about, even if the data is being de-identified when the CDC gets it at a national level, we know that it's probably not de-identified at the local level, because if it was de-identified, then it wouldn't be useful to the local health department, which is doing things like partner notification and referring people for services and doing outreach along those lines. That's also the level that prosecutions happen, right? It's your local district attorney who's making prosecution decisions. And so is de-identification really even an effective way to protect people from the risk of criminalization? Probably not. So, one, big thing that we think we need to think about is this even an effective way of improving public health? So the argument is that if we can make our response to, so-called clusters more targeted, that will more effectively be able to actually reduce HIV transmission. But of course, that depends on using that information effectively to engage people in treatment. And we know that there are other social barriers to getting people into treatment, such as, for example, medical mistrust based on certain patient communities' prior experiences with medical providers and with the public health system generally. If this is something that will enhance medical mistrust by making people mistrustful that doctors will actually use their information that's collected for personal health reasons in a responsible way, is it really going to have ultimate public health benefits? That's something that we need to think about at the front end. Is this even worth the gamble? We are worried about whether it will enhance stigma. A lot of stigmatizing language is included, such as cluster, that is both stigmatizing and pathologizing of people who deserve to be treated with dignity and have their individualized health both data and medical decisions with their doctor respected. So, especially we're thinking about in places like not New York City where I'm sitting right now, but in, say, a rural state where you have a much smaller population. And when you identify people as being part of a cluster, it'll be much more clear who you're talking about. Is this a real risk? Also, we just think part of the conversation needs to be the expense, because we know that this is going to be an expensive program. This is, kind of fancy technology. We're talking about millions of dollars. That's a lot of community health workers. That's a lot of partner notification. That's a lot of PrEP access. Are there other things that we can be doing with that money? And we just think part of the conversation needs to be at the front end, is this how we should be spending it? And finally, we're thinking about consent and just the human rights issue of using data that's gathered by doctors to provide patients with treatment for public health purposes. Is this pose issues of informed consent in using people's personal information in that way? And for example, and this kind of dovetails with a bigger trend that we're seeing. which is just outside of even the HIV surveillance apparatus, but an erosion of state level protections. For example, a legislative proposal in New York that would effectively eliminate notice of HIV testing, and a policy in Louisiana that keeps records of negative STI tests as well as positive STI tests. These are, some things which are related to this, which kind of reflect a similar idea that we can sacrifice respecting individual decisions and patient privacy for the greater good. And we're concerned about kind of straying from our principles in that way. Fortunately, at least in terms of the New York legislative proposal, it hasn't moved yet, and we're hopeful that that the state will see that it's not really an effective approach to moving towards the end of the epidemic. A lot more information about that is on our website, and I know Amir and I would love to hear from people who are interested in learning more about that. Okay, so what can we do about this? And I'm going to talk a little bit quickly because we've been talking for a while. We outlined in our fact sheet a number of possible approaches to both advocacy, how to advocate for yourself and for your community, and how to address some of these holes in the system. These are a few of them. There are a lot more probably that we haven't even thought of yet, and we'd love to hear about. One is just a moratorium on using this technology, period. Another is trying to target our response to some of the issues that we've identified, like insufficient state level health data protections, and asking the CDC to use some of its power as the funder of these programs to get states to implement some best practice protections there. We think that this money, some of this money should be directed towards things that are a priority for the communities we work with, like addressing medical mistrust and more effectively engaging the community to incorporate community input as programs are being developed and not only after the fact. One is, this is just a resource that I would recommend that people take a look at, the Fair Information Practices principle. This is something that I know is referenced a lot in kind of the technological space when it comes to like technological surveillance of like counterterrorism and other kinds of law enforcement. But it's an interesting, I think, useful list of principles that we should keep in mind when we're thinking about appropriate ways to share data. And finally, just, some ways to advocate. We know that this is something that in a lot of jurisdictions, they're talking about end the epidemic plans. Show up at those meetings, ask questions, speak up and push back because the CDC has identified community engagement as kind of a priority in this moment. And so we do think that there's kind of a moment to have some input about this, and we would love to talk with people going forward about different ways that we can support community members who are doing advocacy along these lines. So I think that pretty much wraps things up. Thanks a lot for joining us. These are our email addresses. We covered a lot in an hour. And so obviously we weren't able to go real deep on everything, but I know all of us would love to hear from people who are interested in more information about how to get involved in efforts to effectively repeal HIV criminal laws, and also how to address some of these new frontiers that I was talking about. So thanks a lot, and thanks Amir and Jada for joining me on this.